Arbitrate, Seniority Versus Ability. Your narrator today is the Executive Vice President of the American Arbitration Association, Paul M. Herzog.
The world torn loose. It is good to know that management in the United States are now resolving almost all their disputes over grievances by submitting them to voluntary arbitration. The American Arbitration Association, a non-profit educational agency, brings you this living example of the arbitration process. Its purpose is to show how a dispute over an employee's grievance can be resolved by arbitration instead of through a test of economic strength. You are about to see the reenactment of an actual arbitration case being tried before one of the association's labor tribunals. The arbitrator is entering the hearing room, where company and union... He is now being sworn in by a tribunal clerk of the American Arbitration Association. This dispute arose out of a company's refusal to promote an employee. It has already passed through several earlier steps of the grievance procedure, in accordance with the existing contract between the company and the union. No adjustment proved possible. A demand for arbitration was made by the union. At the request of the arbitrator, it is now being read to the parties. The hearing itself is about to begin.
Mr. Keel, on August 4th, the American Arbitration Association received a copy of a demand for arbitration from the union under a clause in their collective bargaining agreement, providing that all disputes between the parties will be arbitrated under the rules of the American Arbitration Association. The union claims that Paramount Metals violated the collective bargaining agreement by not promoting Sam Wilson to the position of materials handler. The union demands that Sam Wilson be immediately promoted to this job and also that he receive the differential in pay from June 20th, the date of the grievance. The company, in a letter dated August 7th, has denied that there was any contract violation.
Fine, thank you. All right, gentlemen, let us proceed. First, have we noted the appearances for the record?
Stephen C. Vladik for the union, Mr. Keel. This is Mr. Brown, who's the union president, and Sam Wilson, the aggrieved employee.
Mr. Lynch?
My name is Daniel A. Lynch. I'm attorney for Paramount Metal Products, and I have with me Mr. Benjamin Hopkins, who is the personnel director.
Thank you. Well, now, Mr. Vladik, since the union is the moving party, you've brought the case to arbitration. I wish you would make a brief opening statement.
Now, this is a fairly simple case, Mr. Keel, arising out of Mr. Wilson's grievance on or about June 20th. Sam's a laborer in the pool. He's been a laborer in the pool for about 9 years. Management refused to promote him to a material handler in the polishing and buffing department. The boys call the job an expediter's job. A vacancy occurred. The job was posted. There were 2 applicants, Wilson, who has had 9 years in the company, and a fellow by the name of Joe Safford, who is also a laborer. Safford's been with the company for about 3 years. Safford got the job. The grievance was then filed. I think the date was June 20th, requesting that the company promote Wilson immediately and pay him the difference of 8 cents an hour between his job and the expediter's job back to that date. Testimony will show that there's no question about Wilson's ability to do the job. He's done it, can do it, and that he's performed it to the satisfaction of the company. But this job pays 8 cents an hour more. In addition, it provides the opportunity for ultimate promotion to a higher paid job on incentive. We therefore think that the award should be directed to a resolution of this.
You claim he was entitled to this promotion under the contract?
That he was reasonably qualified to perform the work.
All right. Mr. Lynch, would you make a statement on behalf of the company?
I'll be happy to, sir. I think maybe before I make my opening statement, it would be well to introduce,
Fine.
as a joint exhibit, the agreement between the company and the union now in effect.
Is this a correct copy of the agreement, Mr. Vladik?
Yes, and I join in its submission.
Well, we'll receive this as joint exhibit number 1. Would you please mark that, Mr. Clerk? All right, you can proceed, Mr. Lynch.
Well, Mr. Arbitrator, as Mr. Vladek has stated, this is a simple case. The facts are basically not in dispute. Wilson is a laborer, has been with the company for 9 years. He applied for the expediter's job when it opened. The company refused to give it to him. Instead, gave it to a man some years junior to him in point of service. It might be well for you to know a little bit about this job. Basically, the expediter provides a service for polishers and buffers who work under an incentive plan which was negotiated with this union. Now, if this service is not performed in an uninterrupted manner, it can only result in the loss of wages to Sam Wilson's fellow employees and additional cost to the company. Now, the job was not given to Wilson because of his bad attendance record. Direct evidence will be given on his precise record by my company witness.
In other words, that's the specific reason he was rejected?
That's correct, sir. There's no question of his ability to do the job. Of course, the problem is he's not there often enough to do it. We submit that when this case is closed, that the evidence will justify the company's action in turning down Sam Wilson's bid for the job.
All right, fine. Now, as I get the issue, you contend that Wilson should have been given this promotion, while you say he was properly denied the promotion because of his bad attendance record.
That's correct, sir.
All right, would you call your first witness, Mr. Vladek?
Sam, you want to go
Mr. Wilson, would you raise your right hand, please? Do you swear that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Sam, would you give the arbitrator your name, your job title, and the rate of pay which you're currently receiving?
My name is Sam Wilson. I'm a laborer in the labor pool, and I receive $1.65 an hour.
How long have you been with the company?
I've been working there for 9 years.
And what sort of a job does a laborer in the labor pool do?
Well, the laborer in the labor pool, in the morning when you come into work, the supervisor generally assigns you to various jobs that have to be done. And
Now,
he puts you into whatever job he thinks is necessary.
have you ever been assigned to work as an expediter in the polishing and buffing department?
Yes, he's assigned me to that job on occasions.
Any complaint about the way you did the job?
Never complained to me about any.
Has there been any complaint about the way you've done the job anywhere in the plant?
No, nobody's ever complained to me about it.
Have you ever been disciplined or warned or in any way charged with violating any of the company rules?
Never.
Now, would you tell the arbitrator about the bid on the expediter job?
Well, according to the operation there, if a job is open and somebody wants it, you've got to put in a bid for it. So I put in a bid because I knew that the expediter's job was open. And that's what I did, and that's all I know of it.
About when did that happen? Excuse me, Mr. Vladek. About when did that happen?
Oh, about a month ago.
June 20th, about the date?
About that time.
We'll stipulate June 20th as the date.
Fine, thank you.
Now, what happened? Did you get the job?
No, the next thing I know, somebody else got it.
And can you do it? Can you
Oh,
perform?
yes, I've done it there on occasions I said before.
That's all I have of Mr. Wilson, Mr. Keel.
Mr. Lynch, any cross-examination?
If you please, sir. Sam, has anybody for the company ever complained to you about your absentee record?
I'm going to object, Mr. Arbitrator. This is a promotion case, not a case dealing with whether or not he ought to be disciplined for his absenteeism or lateness.
Well, Mr. Arbitrator, discipline is not involved in this situation at all.
She wouldn't give him the promotion.
And that's correct. And for the reason that he just doesn't show up regularly enough.
Well, your question goes to your defense. Now, whether it's a valid defense, we'll decide in connection with the determination of this arbitration, but I'll allow you to go ahead with those questions.
Have you ever received any complaints from anybody in the company about your absentee record?
Well, I've been told once by the personnel supervisor there that I ought to watch my latenesses and absences, and that's what I've been doing. I've been watching them.
Well, now, you have a problem at home with your wife, do you not?
Yes, my wife is sick. She's got rheumatic fever.
And, have your medical advisors given you any idea about how long this is apt to continue?
Well, the doctor told me that this is going to be for a long time. You know, rheumatic fever. She's been sick for a long time. And he knows that I've got a problem with the family. I've got a couple of kids. I've got to take care of them. I've got to see them off to school. I've got to handle some of the problems at home. Well, shucks, a guy can just do so much.
And that's been the reason for your absenteeism?
Yeah.
Well, now, haven't there been occasions, as a matter of fact, when you have been absent from work for reasons totally unconnected with your wife's illness?
I don't recall any.
Well, do you recall on one occasion when you failed to report for work because you'd been drunk the night before?
Oh, I'm good.
Huh?
Well,
This is... All right, Mr. Arbitrator, but this is where you go.
We'll let him. Now, whether it's relevant, we'll decide at a later time, but on cross-examination, we allow wide latitude. Go ahead.
Now, will you answer the question, please?
I don't remember.
You have no recollection?
No.
Now, isn't it a fact that you have been absent on more occasions than any of the other laborers in the laborers' pool?
I don't know about that.
You don't know?
No, I don't.
All right. Now, you say on occasion you have done the expediting job. Is that correct?
Yeah.
Now, on occasions when you have done that work, haven't the men been required, polishers and buffers, been required to wait for you to bring the materials to work on?
Yeah.
And doesn't that, as a matter of fact, result in a loss in wages to the polishers and buffers?
I don't know, but look, I'm not doing that job all the time.
Well, that's precisely the point. And if you were given the job and your absence and lateness record continued, wouldn't we have to continuously replace you with another laborer from the pool?
That I don't know.
That you don't know.
Well, I think if I noted Mr. Vladek's look, that was argumentative, Mr. Lynch.
I think it's speculative in addition to argumentative.
Well, I think it's completely relevant to this proceeding.
Well, we'll save the argument for later.
Thank you. Well, can you answer this question? If you fail to bring materials to the polishers and buffers to work on, it will result in increased cost to the company for production they do not receive.
Oh, now, I'm going to object to that. This is pure speculation, Mr.
Well, I think
Keeler.
he can answer that question if he knows.
Well, it's close, but I'll allow the question.
What's the question?
The question is, when you fail to bring work to the polishers and buffers on time, of necessity, it's going to result in increased cost to the company for which they get no production.
I don't know about that.
You don't know?
I don't know.
All right, I have no further questions.
Any redirect, Mr. Vladek?
Yes, Mr. Keel. Mr. Wilson, would it refresh your recollection if I reminded you of a company party after which you and your supervisor went out to have a little party of your own?
Oh, yeah. I mean, that thing.
Did you tell the arbitrator about it, Mr. Wilson?
Yeah, we sometimes have a party that's run in a department. And some other guys sort of get together. And we have
Is this in the plant?
Yeah. But it's all right. I mean, there's no monkey business there. But after the party, a couple of guys got together and we went down to the bar on a corner. And we had our supervisor, my supervisor was there, and a couple of others, fellas and some other supervisors, and we were drinking, and maybe I had a little too much. I got sick. I got home. I couldn't go into work the next day, and I called up. I told them I was sick. I couldn't show.
And your supervisor knew where you had been and why you were sick?
Yeah, he was with me. He was drinking just as much as I was.
He must be better equipped for it, Sam.
I should move that be stricken.
I'll withdraw it. Mr. Wilson, on these occasions when you were filling in the polishing and buffing department, was that because the expediter who was regularly there was absent?
Yes, that's the only reason I'd go in there.
And how often had you done this job in the polishing and buffing department?
On various occasions.
I have nothing further.
But only occasionally, isn't that so?
Yeah.
Now, you wouldn't have the arbitrator believe that you were doing any drinking on the company premises, would you?
Oh, no, I told him. We went to the bar in the corner.
And,
I never drink on the job.
and you reported in sick the next day because you had
I
too much to drink the night before.
Yeah, I called up and I told him I was sick.
Now, you say one of your supervisor was drinking with you at the saloon.
Yeah, my supervisor, the guy that tells me what to do.
Now, do you know whether or not he appeared for work on the next day?
I don't check in him. I don't know.
I have no further questions.
All right. Step down, Mr. Wilson. Would you call your next witness, Mr. Vladek?
Mr. Brown?
Mr. Brown, would you raise your right hand, please? You swear that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sit down, please.
Mr. Brown, would you give the arbitrator your name and position?
My name's Ralph Brown. I'm president of Local 100.
And as president of the local, did you negotiate, and are you familiar with the agreement and evidence as Joint Exhibit 1?
I am.
Would you tell the arbitrator about the promotion section in that contract?
Well, when there's a better job opening up, notice must be posted for 3 days in advance. There's 3 working days before the job's filled. Gives the men a chance to bid on the job if they're qualified, and the man with the most seniority gets the job, provided he's qualified.
I wonder, Mr. Vladek, if we shouldn't have the precise section before us. Could you tell me which one that is?
Yeah, I have the original here, Mr. Keel. It's on page 14, I think, of that contract, Article 7.
Yes, I have it now.
When any vacancy occurs within the bargaining unit, it shall be filled on the basis of seniority, provided the senior employee is reasonably qualified to perform the duties of that position. Notice of such vacancy shall be posted on the bulletin board at least 3 working days before the vacancy is filled. Employees shall have the right to bid for the job within that period of time.
See. So the question is whether Mr. Wilson, the senior employee, is reasonably qualified to perform the duties of the position.
That's our position exactly, Mr.
And
Keel.
ours, too.
Fine, thank you.
Now, Mr. Brown, did the company comply with the contract when the vacancy occurred, the material handler, expediter job?
Oh, they did as far as the posting of the notice is concerned, but Sam Wilson didn't get the job. Even though he's got the seniority, man with less seniority got the job.
As president of the union, are you familiar with Wilson's ability, his work performance, and his conduct in the plant?
Sam is a good worker.
And any question about disciplining him in any way because of a lack of qualification?
He's never really been disciplined.
Your witness.
Mr. Lynch?
Well, Mr. Brown, in your capacity as president of the local union, do you participate in grievance meetings with the company?
I do.
And on occasion, have company representatives discuss with you various problems come up in the shop?
Most of the major problems.
Has anybody for the company ever discussed with you the question of Sam Wilson's attendance record?
Well, the matter has come up, but everybody knows Sam's a good and responsible worker. He's got some family problems. He may not always get into work on time, but the company's never given him more than oral warning. I think that proves they're making too much out of this case.
But they have given him an oral warning.
Occasionally.
And they have taken it to you in your capacity as president of the local.
Yes.
Now, polishers and buffers, can you tell us whether or not they are working under an incentive plan?
Yes, they are.
And isn't it true that if the materials do not flow smoothly into the polishers and buffers, that they are bound to lose some of their earnings because of downtime?
To a certain extent. They lose the first 5 minutes. But if they lose more than 5 minutes in waiting time, then they're paid at average earnings for the whole time.
And that means then that the company is required to pay for production it is not getting.
Is Lynch testifying now instead of Brown?
I submit that that's a question.
Well, the question is on cross-examination. It is a leading question, but can you answer it?
Well, look, the company assumes a certain amount of downtime on all the jobs. And they take this into consideration whenever they're setting their wage rates on an incentive job.
Well, you'll be able to argue this point when we come to the summation.
Well, now, as a matter of fact, isn't it better for the polishers and buffers to have the work moved to them smoothly in order to avoid loss of wages?
I agree with that.
And in order to avoid loss of, in production costs to the company?
Yeah.
I have no further questions.
Union rests subject to rebuttal on the closing statement.
In other words, that completes your witnesses.
Yes, sir.
Mr. Lynch, would you proceed with your witnesses?
If you please, I call Benjamin Hopkins.
Stop it. You raise your right hand, please. Do you swear that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sit down, please.
Now, Mr. Hopkins, will you give your name and your official position with Paramount Metal Products Company?
Benjamin Hopkins, Personnel Director.
And among your duties, are you required to pass upon such things as promotions and transfers and assignments to jobs?
Yes, in many instances, foremen give recommendations, but in the final analysis, the decisions are mine.
Now, are you familiar with Sam Wilson's record of employment with the company?
I'm quite familiar with his record.
Would you please give me the record? Mr. Arbitrator, I offer this in evidence.
I object, Mr. Keel.
What's the basis for your objection?
This is not a discipline case. Whether Mr. Wilson's attendance record is good, bad, or indifferent isn't relevant here. But even if it were relevant, his record standing alone, without comparison to the 300 or 400 other employees, is meaningless. And I think that if the company wants to introduce it, let them introduce all of the records, particularly those of people who have been promoted under Article 7 in the past.
Mr. Lynch, you have anything to add to that?
Well, sir, I agree with Mr. Vladek that discipline is not involved in this case, nor do we offer that document for the purpose of sustaining any disciplinary action because we took none. Sole issue here is whether or not Sam Wilson is reasonably qualified to perform the expediter's job.
Well, you know, in these arbitrations, we don't follow the technical rules of evidence. We try to get to the heart of the issue. And on that basis, I'm going to let it in. As to whether his absence was relevant to the case, that is a matter for argumentation. As to the other records, we'll see later whether they're necessary to be put in. I'll accept this as evidence.
Has this been marked?
Would you please have this marked, Mr. Clerk?
This is marked Company Exhibit Number 1.
Now, would you please tell the arbitrator what this record discloses?
In the last 12 months, Sam Wilson was scheduled to work 220 days. He was absent a total of 30 days. He was late more than 15 minutes on 45 other days. 50% of his recorded latenesses were in excess of 3 hours. We don't record absences, we don't record latenesses, rather, of less than 15 minutes.
Now, have you discussed this record with Sam Wilson and with the union?
Yes, on a number of occasions I have. Actually, we've been, I think, somewhat lenient, maybe unwisely. We realize that Sam has a rather serious home problem. However, I have had to remind him that on occasions, his absences weren't altogether authorized.
Well, can you tell us how many of these absences have been totally unrelated to his wife's illness?
To my knowledge, 8 occasions.
Now, can you tell of any specific one of those that would be of interest to the arbitrator and germane to this proceeding?
Well, the incident involving the track.
Would you please tell us about that incident?
Well, I belong to a personnel association, and we had a day's outing, which happened to be at Aqueduct Racetrack. In using the glasses and scanning the track, I find our employee, Sam Wilson, on the rail in the bright sunlight enjoying the races as I was. The next day, on returning to work, I called Sam in and confronted him with this information. He didn't deny it. He said that he had been there under doctor's advice because he had a bad back, and the doctor told him to get a day's rest and to get out in the sun. This was his way of doing it.
Now, will you tell the arbitrator, please, the precise reason why you refused to give Sam Wilson the promotion?
Oh, simply because he's completely unreliable. We feel that Sam could probably do the job if he came to work, or even when he came to work, if he came to work on time. We will not continually be put in a position where we're going to assign other laborers from the labor pool to this particular buffing and polishing department. It causes too much lost time for the piece workers and a loss in money for them, and a result, it's far too expensive for the company.
You may examine, Mr. Black.
Was this day at the track a work day?
Yes, it was, sir.
And you were there?
I was, sir, yes.
With the permission of the company?
That is correct, sir.
Did you get paid for the day?
I did.
How'd you make out?
Oh, I broke about even.
Now, did you check with Sam's physician as to the story that Sam gave you?
I did.
What did he tell you?
He said that he had advised Sam, because of this back ailment, to take a day off, rest, and get a little sun. He didn't specify the track.
Sunny day at the track, though, wasn't it?
It happened to be, but I wonder, would he have been there were it raining?
Well, we won't know the answer to that.
No.
Was Sam paid for the day?
He may have been, I don't know.
Now, how many employees do you have in the bargaining unit at your company?
430 approximately.
And absenteeism is a problem?
On occasions, yes.
How do you handle it?
Well, in a variety of ways. We often talk to the men about their problems. We issue formal notices. Sometimes we may lay off. And as I'm sure you're well aware, last year we discharged a man for chronic absenteeism.
In other words, you handle it as a discipline problem by reason of the fact that the men are violating your rules.
That's right, that's right. But that's not the case here.
Have you ever before denied anyone a promotion or a vacation or time and a half for overtime or sick leave because of absenteeism?
No, and as I said, this is not a disciplinary matter with Sam Wilson.
You're familiar with the contract, Mr. Hopkins. Do you recall the first sentence of Article 7?
I don't have it memorized, but I know basically what it says.
It says reasonably qualified.
It does.
And doesn't the contract, when it talks of reasonably qualified, isn't it silent with regard to absenteeism, for example?
Well, it doesn't specify absenteeism any more than it specifies that a man shall have 2 arms. However, we feel that lateness and absence certainly should be taken into consideration in promotion.
But when you negotiated the contract with the union, it was your understanding, the union's understanding, that reasonably qualified meant the technical ability to do the job.
Oh, probably the exact words might be skill and efficiency, but certainly a man can't do the job if he doesn't come to work. He has to be there to perform, and this is what we did in Sam's case.
That's true of everybody. Everybody has to be there in order to do the work. Was there ever a case before where you denied anyone a contract benefit, like a promotion, because of absenteeism?
No, we've never had to. We've never had a record like this.
That's all I have of this one.
Do you have any other questions?
Oh, yes, I have one, if you please. Mr. Hopkins, you heard Sam Wilson's testimony about the office party and the subsequent party he had in the neighboring saloon.
I did, sir, yes.
And you heard him testify that he had 1 or 2 too many to drink, and as a result was unable to come to work the next day, and he called in sick.
I did.
Now, do you know Sam's supervisor?
I do.
The one who was with him that night?
Yes, sir.
Do you know whether he reported for work the next day?
He did, sir.
Do you know whether he reported on time?
He was ahead of time.
I have no further questions.
Better trained than up all night. I have no more questions.
That's our case, sir.
That completes your case. Well, gentlemen, you have now presented all of the evidence, and I would call upon you to make your summations. Vladek, you will go first.
Mr. Keel, as I stated at the opening, this is a simple case. The contract says that the senior man, if he is reasonably qualified, is entitled to the promotion. There is no question about Wilson's ability to perform the job. He's done it in the past, and the company concedes that he's qualified to perform it. And the promotion is a matter of right, not of privilege. The company now says, well, he's been absent. And we think that because he's been absent, we're going to discipline him in effect by depriving him of 8 cents an hour and the opportunity for future advancement. If he has been absent too much, the company can discipline, and we can test that to determine whether or not just and sufficient cause exists under the appropriate section of the contract. But where we're talking of reasonable qualification, neither the company nor the union intended the application which the company has placed upon those words here. And they're seeking to have you construe the contract in a way not by either party agreed to at the bargaining table where such discussion should take place. We submit to you that Wilson was improperly denied a promotion, that the company violated the contract, and that Wilson should be promoted retroactive to June 20th, 1961, to the position of expediter material handler and pay the 8 cents per hour differential which he's lost.
Thank you, Mr. Vladek. Mr. Lynch?
Well, sir, in the first place, I respectfully submit that you, as the arbitrator, have no power to substitute your judgment for the company's judgment, unless you find that the company has violated one of the clauses of that contract, and we submit that there hasn't been a scintilla of evidence presented here to indicate that we did. I agree with Mr. Vladek that this is a simple case. I also agree with him that discipline isn't involved. This is just a clever twist on the part of the union to make this case seem something different from what it actually is. The contract requires us to give the job a promotion to the senior man, provided he is reasonably qualified to do the work. Reasonable qualifications means more than just skill or ability to do the job. Of necessity, it includes reliability. Of necessity, it means that the man who gets it is going to attend to the job regularly. We submit that it would be a travesty to have you order us to put a man on this job when it is certain that his fellow workers are thereby going to lose money, and the company is going to be required to pay production costs for work it doesn't get. We submit that this grievance should be dismissed. Thank you.
All right. Thank you, gentlemen. You have very succinctly presented the issue in dispute. The facts are not in controversy. You have given me an issue of interpretation of the seniority clause. I will now declare the hearing closed, and I will render my decision as quickly as possible. Thank you very much.
Thank you, sir.
Mr. Black, see you again. Mr. Lynch. See you.
Under the rules of the arbitration, the arbitrator now has 30 days at the most in which to write his award and his opinion. He will base his award on the evidence presented to him, upon the contract, upon the documents presented, and of course upon the oral testimony, and also upon the arguments of opposing counsel. You too have now heard all the evidence and heard all the argument. You be the arbitrator. How would you decide this case?
Cast, Paul M. Herzog, narrator. Theodore W. Keel, arbitrator. E. Robert Krieger, tribunal clerk. For the union, Stephen C. Vladek of the New York Bar. Sam Kovanetsky, president of Local 1S, Retail Wholesale Department Store Workers, AFL-CIO. John J. Dillon, Education Director, Region 9A, United Automobile Workers, AFL-CIO. For the company, Daniel A. Lynch of the New York Bar. Martin J. Quinn, the Industrial Relations Division of Safeway Stores Incorporated.